To another of Professor Sankoff's seminars. I am really excited about 2022 in general because this is a big year for our little project. Thanks to the support of all of you and many, many more. We are continuing to expand what we do, and I'm just excited about every aspect of it. You're going to keep seeing notices about new things that we're doing in coming weeks. So we've got amazing seminars. I'm not going to go through them all. You know them. We've got just amazing seminars. I'm really excited. Next month is about ethics and professional practice. It is essentially, it's really great. Daniel Song, Daniel Brown, and Professor Amy Salzin are coming together to answer questions that most of you have submitted. They're great questions about the most difficult ethical and practice dilemmas. To be clear, it's not about building a practice. I have another seminar on that coming, but it's about dealing with really thorny client problems, and they're great, and I hope we can get through them all, and it's really fantastic. So I'm really looking forward to that as much as any seminar this year. We have a second full year of case alerts. I've already recorded a bunch of them over the holidays. We have a really good case out of Ontario on electronic records. It's also very new. For those longtime case alert viewers, I made the very poor decision in the past of numbering case alerts, which gave me no flexibility of putting in more important ones when they came out. That is gone now. I don't have to number them anymore. And as a result, I did JK, and I thought it was so topical, it's going in today. So you're going to get a good case out of Ontario on electronic records, and then some really important Supreme Court of Canada decisions from the last term. It's our first full year of the Golden Thread. To say I'm excited about this, I hope listeners and readers like it as much as I do, is an understatement. With the Golden Thread, just to whet your appetites, like the types of things we're trying to do. As many of you know, we're doing a year-long exploration into what it's like to article at the defense bar for both principals and articling students. And we're going to explore concerns and good parts of that experience. That's for the whole year. The things that we're trying to do, we're really trying to be cutting edge in the types of things that we put into the Golden Thread. So right now, there's a case out of Edmonton today. I don't know if anybody heard about it. The police are investigating a potential case of an anti-vax person paying homeless people to get vaccines under their name and then using the QR code to get into restaurants and stuff. I don't know if that's true or not, but as a hypothetical, it's magnificent to begin with. Terrible in reality, but magnificent as a hypothetical. And I can tell you that right now, Professor Michael Plaxton of the University of Saskatchewan and I are involved in a back and forth email thread that's going to be reposted in the Golden Thread, going through all the potential liabilities. We've just started it, and it's fantastic. So I think for anybody who likes that sort of stuff, there's really great stuff coming in the Golden Thread. Other surprises, as I said, I'll leave to another day. As I said, we've got the long year and the long focus of articling. So we have a lot of contributors at this point, but if you'd like to say something about that, we'd like to hear from you. And if you've never gotten the Golden Thread, just let us know, and you're entitled to a free copy to see what we're up to. All right, what is next? Oh, sorry, I had the seminars. Those are the great seminars that we have coming up. This one's free, by the way. If you are not an annual pass holder here today and you just want to check out a free one, like you can sign up for this anytime. It will fill up because it's open to the entire world. So the May 11th seminar, you just go to our website. You still have to register on our website, but you'll see there's no cost. It's free. So you just click on that and you get automatically registered. Those of you who are annual pass holders, you don't have to worry about that. You will be automatically registered, and you can go or not go. That's totally up to you. First, I'm going to set out the general principles on character evidence for Crown witnesses and victims. Second, I'm going to talk about character evidence and its usage in cross-examination. Third, I'll talk about the particular area that is referred to as third-party suspect. Fourth, we'll look at character evidence of a victim or complainant who is not testifying. That's the key distinction between numbers 2 and 4. 5, I'm going to do very briefly on police officers who raise some particular issues. 6, we'll talk about the going after a co-accused with character evidence. And finally, hold on. Video seems to keep popping on for people today, so I'm going to stop it. There we go. And finally, good character evidence, prosecution witnesses, when can it be adduced? And then we'll have some Q&A. So let's get started. Let's talk about general principles on character evidence involving Crown, witnesses, and victims. So here's my first question. This is the question to all of you. Interesting answers. Take your best shot. Very, very interesting. So I will stop it there. The most popular answer was B, generally permissible. Some said occasionally, some said rarely, and 34% said almost always permissible. To me, this question is not really a matter of debate because the answer is A. It is almost always permissible in every setting, just about. It is just, it cannot be C or D because the questioning comes all the time and, as I'll show you, is allowed. But more importantly, it is permissible because we are not talking about the accused. That is the biggest difference, and that is the reason why it skews so heavily in favor of cross-examination. In fact, with a few minor limitations, you can question or a Crown witness about anything, bad character. It's really open season. That is the way that it is done. Let me keep going with this. So the starting point is you have to keep your focus. You have to. It's just, you cannot get distracted by rules or distracted by the Crown using rules designed for the accused. It's just so important. We're focused on these people. So questioning these people, Crown witnesses, right? And by the way, I should add, don't be distracted by Section 276, which sets out very strong restrictions of what you can do about sexual activity. That is not the standard. It's just not. We are focused on Crown witnesses. We are not trying to protect the accused. And to be perfectly honest, look at the language of propensity evidence when you're dealing with the accused. Like, you can't do it. It's a forbidden chain of reasoning. You cannot do it. If you look at BCR, if you do this, there's a strong inclination to conclude that a thief steals, a violent guy fights, and a pedophile pedophiles. But you cannot do it. No, 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 no. By the way, I would argue that Justice Sapinka's got it wrong here. Just a little bit, because with juries, I'm less worried of being inclined to think that a thief has stolen, because often that'll get in some way, or that a violent man is assaulted, right? Because like with similar fact evidence, that's already got a bit of similarity. I'm even more worried about just the generic bad character references, which again, keep that in mind because it's very different when you're going after a Crown witnesses. Like you're going to see, you can use almost any trait that has some relevance, right? A violent man, this is what I'm worried about. And that has to be cut out of the equation. So why does this matter? Well, look at that quote. You have to remember this, and people tend to forget. They think that propensity evidence is inadmissible, but it's not inadmissible because it's irrelevant. It's relevant. Every case on propensity says this. So you, as defense counsel, can always argue propensity to a witness because it's relevant. As long as it has a sufficient connection for relevance, which is a very low threshold, it is admissible, subject to what we're going to discuss. So when you put all this together, like now we see, this is a case, Bishop, by the way, about character evidence of a Crown witness. You can't stop the accused from doing it because of the balance for excluding defense evidence, which is a substantially outweighed prejudicial effect. So it's just such a big deal when you put all the case law together. That's it, right? The prejudicial effect outweighs the probative value, but for the defense, it doesn't work that way. The prejudicial effect has to substantially outweigh the probative value, which is why the courts tend to be lenient, or they should be lenient. Sometimes they're not, and that is a real issue. You will see it really does alter it. This is one of the ways I like to visually show my students about how we think about evidence. That's for the Crown. That's for all evidence. The Crown starts with an even balance. They have to show that the probative value outweighs the prejudice. But like with character evidence, there is a presumption that the prejudice outweighs the probative. So every time, I kid you not, every time the Crown wants to adduce character evidence against the accused, they have to tip the balance. It doesn't work that way for the defense. With the defense, it starts this way. Do you know that? Every relevant piece of evidence, you have to get over relevance, but every relevant piece of evidence looks like that. That's what it looks like. So therefore, when you start tipping the prejudice, it's got to do a lot of weight here before this evidence is going to be excluded. And as Naomi Klein would say, this changes everything. It really does. It changes the entire balance. It changes the entire way in which we look at the evidence. So I urge everybody, my first tip, and many of you know this, but I'm sometimes convinced in looking at the transcripts that judges don't know this, that character evidence is prima facie admissible for the defense, as long as it has some relevance. And relevance is a very low threshold, some tangential connection to the proposition you are trying to prove. That's it. So you don't need to bring in the test for handy or similar fact evidence. Don't care about that. Go to town. You've got a bad witness or a bad Crown or a bad anything. Grill them subject to the things that I'm going to suggest where there are particular impediments to doing so. Hope that's clear because it's extremely important. Now, how do you do that? You also have to focus on the fact that the concerns are different. So when you're dealing with bad character evidence involving an accused, you're in good position to exclude the evidence. And one of the reasons for that is because there are two distinct types of prejudice. So no matter how probative the Crown says it is, there are two. One is moral prejudice. Well, moral prejudice is based on the idea that the witness will be disadvantaged, and the witness is the accused. So the accused is going to go to jail because they're a bad person. But with an ordinary witness, moral prejudice is really not a concern. It's really not. And don't let the Crown give you stuff like, oh, the dignity and all this stuff of the witness. Those quotes I gave you earlier make it clear that all that stuff has to be secondary to the need of the accused to avoid the risk of conviction. The only prejudice you really should allow them to throw at you is reasoning prejudice. That still exists. It does. And you'll see it come out in the cases that I'm describing. In effect, they will sometimes exclude bad character evidence of a witness where there is a real risk that the evidence is going to divert from the trial. And you all know the trial's primary purpose is to see whether this accused committed this crime. So if you risk turning this into a diversionary exercise about the witness and what they did, that is the common theme that comes out. The worry that the jury is going to be confused, is going to be misled, or is going to have too much time taken up. That's really what the concern is in these cases. So make sure you focus your arguments. And here are my suggestions. Always, anytime you start hearing anybody throws handy at you or all that stuff, no, it's just that is not the way this works. You throw them the test, you throw them bishop, and that is the imbalance. You can explain the probative value links, but I want to make clear, I hope everybody understands what I mean can be more generalized. The reason for that is the balance. When the Crown is trying to admit evidence of bad character against your client, the balance is out of whack, right? The prejudicial effect is so high that they have to really strengthen their probative value. So they've got to show it's similar. They've got to show there's enough bad stuff in there to connect to the accused that it tips it up towards admissibility. But with the victim or the witness, it's the reverse. Prejudicial effect is up here, right? The probative value is already down. So long as you can show there's enough of a connection, right? They robbed a store once, therefore they're a violent person. They cheated on their taxes, therefore they're more likely to lie in court. Go to town. It's really, it doesn't require that much. You've just got to be able to establish an inference. Let me be clear. If the inference, and I'm going to go through all the different inferences that I think are available, but if the inference is just about credibility, it's really easy. You just show, well, they did something bad in the past. So therefore, I think they're more likely to lie than the average person. I'll stress to you that that almost always works unless what they did bad in the past is so far away or so tangential that they might be excluded as irrelevant. But otherwise, these things can be done, and they can be done in a more general way. That's the beauty of attacking a crown witness as opposed to being the accused. One of the few areas of law where the law really, excuse me, is really in favor of the accused person. Moral prejudice, as I said, is less of a concern. And stress, let me stress this, where you can, also point to the absence of reasoning prejudice. Now, again, you won't always be able to do that. Reasoning prejudice is a case-by-case thing. It depends on how focused is the inquiry. It's really short. You're not trying to explore a detailed conspiracy. And if the facts are not in dispute, it's admitted that the witness did that, there's less reasoning prejudice. So you're trying to focus down and say why this should be permitted. Okay, so with that in mind, here is the question of the day, or at least the question of the moment. Well, I mean, look at these results. They're beautiful. So 13 people say that's correct based on probably what I already said. B say not quite. And C say, you know, I smell it.
Admiral, we have enemy ships in Sector 47.
It's a trap.
It is a trap. I got to be honest with you. It's a trap because the question as posed says you can admit evidence of bad character if the probative value outweighs the prejudice, right? And again, I took sexual activity off the table, so that's not the answer. That has nothing to do with it. The question is not correct. And the reason is, as always, like all rules of evidence, all questions are answered. Why are you adducing the evidence? That is the dividing line here between it's admissible or it's not. You ready? Why are you admitting the evidence? That's the question here. Is it for credibility or is it for substantive purposes? Because if it's for credibility, you cannot admit the evidence to contradict the witness unless it satisfies the collateral fact rule. So in other words, there is a difference, and it's a huge difference, because if it has a substantive purpose, like one of the ones I'm going to show you, it doesn't matter what the witness says, whether they agree with it or not. You can adduce the evidence. In fact, there doesn't have to be a witness. The evidence is substantively admissible on its own merits. But where there's bad character evidence, you say to somebody, just for an example, you say, okay, so you're agreeing that you stole from something or whatever. And the witness says, no, I never did that. Well, why are you admitting that they stole something? If you're admitting it just to show that their type of person would lie, you can't admit evidence of the theft unless it's a conviction, because that's an exception to the collateral fact rule. So I want to make clear that there is one other big rule that stops you from adducing character evidence in a trial. If it's for any other purpose, it's admissible. So anytime you can link it to a relevant propensity beyond lying, if it's lying, you're stuck with the collateral fact rule. But for anything else, you can admit it. If any of that is confusing to you, I can't go into this in great depth. I just recommend you, as I'll show you in a minute, I forgot I had another slide, to look at my video on collateral facts. But here is the breakdown. You can question any witness and you can adduce bad character evidence as long as it has a non-credibility purpose. And let me be clear, it can also have a credibility purpose. That's true too, right? And I'll show you examples of that. You can always adduce bad character evidence as part of your case if it's relevant to something other than credibility. You can question any witness about bad character traits to weaken credibility, but you can't adduce evidence of it without complying with the collateral fact rule. Oh, somebody said, in my mind, if it's collateral or irrelevant, it's not probative, but maybe that's blurring the lines. So to that person, I would say this: collateral and irrelevant are not the same thing. The distinction is major. And the distinction, I can explain it to you like this. My example about stealing is a good one. Let's say you've got a witness who's charged with assault. Sorry, you've got an accused charged with assault, and he's saying that the guy punched him first and it was self-defense. Very, very simple. Okay, so you go up and you start questioning the guy and you say, well, do you regularly shoplift from various stores? Okay, is that questioning permissible? Yes, it's permissible. It's bad character evidence. It has some relevance. It shows he's the type of guy who's dishonest and might be lying. But if the guy says no to you and you want to show 10 videos of him shoplifting, you can't. because that's collateral. So collateral and irrelevant are not the same thing, nor is collateral the same as not probative. They are very, very different things. And again, if you want more on that, I go through that in depth in my collateral facts video, strategic guide. So like I've been through this in depth. It's all there. And that distinction is so, so important. So keep that in mind. In fact, in the collateral facts video, I go through a long thing about Crown objections saying something's collateral, and I get pretty outraged, I recall. I get really mad about that because there is no such thing as a collateral question. No such thing. It doesn't exist. There is only a collateral admission of particular facts. Thanks so much for watching a portion of this seminar on character evidence. If you'd like to see the entire recording, visit us at petersankoff.com.